Friends, good evening. Let us solve one more question relating to advocate on record examination. The question is, explain in brief what is the procedure of filing a public interest litigation under the Supreme Court Rules 2013. Friends, this is the question. Now, friends, the procedure is defined under Order 38, Rule 12, as per Supreme Court Rules 2013. So, firstly, I will read out Rule Order 38, Rule 12. What it says. A public interest petition may commence in any of the following manners. Firstly, I am reading out Rule 12. Its first part, mean to say 12 subclause 1. It says that public interest litigation may commence firstly as a suo motu, when ordered by the Chief Justice or Judge of the High Court. Second is when a letter or representation is given and the Chief Justice or the judge nominated by Chief Justice may order it to be public interest litigation. Third is when a simple petition is filed, but keeping in view the contents, order of the court to treat this petition as a public interest litigation. And fourth one is by presentation of petition in the court, means by presentation of public interest litigation in the court. So our question is related to this part, fourth one. They are asking for procedure of filing public interest litigation. So friends, when this public interest litigation is filed, there are necessary compliances which we have to do to get good results. The first compliance, this order says that the petitioner should disclose his full name, complete postal address, email address, phone number, proof regarding personal identification, occupation, annual income, PAN number, national joint identity card number. So firstly, he had to disclose these. Friends, it also says that facts, which are compulsory in every petition. So facts consisting the cause of action is to be explained. Nature of injury, caused or likely to be caused to the public. This is to be explained. Nature and extent of personal interest, if any, of the petitioner. Petitioner has to disclose his personal interest also. And he had to disclose any civil, criminal, or revenue litigation involving the petitioner. If there are more petitioner than involving any one of the petitioner, which has or could have legal nexus with the issues involved in the public interest litigation. So he had to explain these also. And he has to tell whether the concerned government authority was moved for relief sought in the petition. If so, with what results? Next, he had to file an affidavit stating that there is no personal gain, private motive, or oblique reason in filing the public interest litigation. Now, Rule 12, third part, mean third clause. It says it is warning to the public interest litigation that the court may impose exemplary costs on the petitioner or petitioner if it finds that the petitioner was frivolous, or instituted with oblique or malified motives or lacks bona fides. So these are the provisions. Now I am giving summary of these provisions. What net result comes out? So friends, the procedure for filing public interest litigation in the Supreme Court of India is governed by Supreme Court Rule 2013, Order 38, Rule 12 and 13. Now, filing the public petition. The PIL can be filed directly in the Supreme Court under Article 32 of the Constitution of India, which provides the right to approach the Supreme Court for enforcement of fundamental rights. So, what is the process? Firstly, we will prepare petition. Petition format is the PIL petition must be prepared in the prescribed format as per Supreme Court rules. There is format which generally say that it should be differently paragraphed for each cause, and so many, it should be readable properly. So these are the general provisions which are also applicable to our public interest litigation. The petitioner should file a written petition, clearly stating the issues, facts, along with the relief sought. The petition must outline the public interest involved and how the issues affect a significant portion of the population. And he had to disclose whether the concerned public authority was approached. If approached, what is the result? He had to supporting documents. There are sometimes news in the paper that such and such of injury has been caused, which are self-speaking. So we have to produce documents, relevant documents, and affidavit must be attached to the petition. The petitioner need to show that the issue is of public importance and not a private or individual grievance. So when petition is ready, it has to be filed somewhere. It is filed in the registry. The PIL is to be filed in the registry of the Supreme Court. The petition must be filed by an advocate on record or directly. Sometimes petition come directly. They can file, petition can be filed directly, but it is better if the petition, it is carrying important cause of the larger public. There are so many advocates of public spirited person, they can join you and sign the papers. The petition must be signed by the petitioner or the petitioner's advocate. Now, friends, there is no court fees. Public interest litigations are typically exempted from court fees, provided the petition is based on a genuine public cause and not for personal or private gains. Now, the question is procedure, about procedure. Now, the first procedure is when we file the application, public interest litigation, then it comes for preliminary hearing. After the PIL is filed, it is listed for preliminary hearing before the court. The court examines whether the PIL satisfies the criteria for public interest and whether it raises a legitimate issue. If the court finds the petition to be maintainable, it will issue notice to the respondents, such as government or concerned authorities. If the court deems the petition frivolous, it may dismiss it at the preliminary stage. Now, sometimes the public interest petition talks about something which there is immediate relief required. So in those issues, if the issue raised is urgent or requires immediate attention, the Supreme Court may issue interim orders or directions to the concerned authorities. to take temporary actions pending the final hearing of the case. Now, there comes regular hearing. Once the petition is admitted, it is heard by a bench of Supreme Court as per the contents in the petition. Friends, if the petition points toward constitutional matters, then the minimum requirement is of 5 judges bench. Or sometime if it is of light view, then in exceptional circumstances it can be heard by lesser than 5. Generally, it is the criteria is of 5 judge bench. During the hearing, the petitioner or their advocate present the arguments. Respondents are given chance to counter the claim. Sometimes these are public interest litigations. The honorable courts ask for amicus curiae, who is the reputed personality or senior advocate. He may be joined or the expert in that particular cause which is raised in the public interest litigation that may be joined as a amicus curiae. And he gives valuable neutral person. He gives a valuable advice and helps the court in proper way. Now, when these things happen, there will be decision. So, final decision after hearing all the parties and considering the legal and factual aspects, Honorable Supreme Court delivers a final judgment on the PIL. Court may provide directions for enforcing public interest, pass order for policy changes, or direct the government or other authorities to take specific action to rectify the situation. Now coming to frivolous public interest litigation. If that happens, there is a cost on the public interest litigator. If the Supreme Court finds a public interest litigation to be frivolous or vexatious, it may impose cost on the petitioner as a penalty for wasting judicial time. This has been a deterrent to the misuse of public interest litigation. So, friends, let me conclude. Spoken too much. The procedure for filing the public interest litigation in the Supreme Court under the Supreme Court Rules 2013 is covered under Order 38, Rule 12, Subclause 1, 2, 3. The various steps involved are preparation of the petition, outlining the public interest issue, filing of the petition with the appropriate document and affidavit, preliminary hearing, where court determines if the PIL is maintainable. If admitted, full hearing takes place, followed by court's final decision. So this is the overall procedure, friends, which I have explained as per my ability and knowledge. You can go further, read further documents if you want more about this. Thank you for watching. See you again. God bless you all. Have a good marks and clear your exam in first attempt.